Ed Robson here from Robson & Robson PC. Robson & Robson PC is a business law firm located outside of Philadelphia. We focus our practice on closely held businesses and their owners. I'm the managing member of the firm, and I focus my practice on commercial litigation. Today, what I want to talk about is some of the things that a plaintiff or potential plaintiff who's considering getting involved in a piece of commercial litigation should consider before they do so. And when I say commercial litigation, it can be anything. It can be a shareholder dispute, a dispute between business owners themselves, a dispute between a business and a former employee, a non-compete issue, an unfair competition issue. Could be a case between business competitors, a tortious interference claim, for example, a breach of contract claim. Could be a variety of things. And every year we have dozens of clients and potential clients who bring viable plaintiff's claims to us of a variety of flavors. Many of those claims, though, are never brought into suit. And the reason is because we like to counsel our clients on some of the considerations outside the four corners of the courtroom that they need to consider before they take that step and put the case into suit. As much as we love litigating, we have to consider the full picture. So the first thing we ask a client who's considering a plaintiff's case is, what do you want to happen? What does a win look like to you? And oftentimes we'll get the answers that you'd expect, and they're good answers. I want money. They breach the contract. We need money as a result. Sometimes they'll say, I want an injunction. An injunction is an order from a court to do or not do something. The president of the company left. He stole the customers, he stole the customer list, he stole our confidential information, and I want a court to order him to return the information and not work for the competitor. That's an injunction. Money and injunctions are the currency that courts deal in. That's typically all they can offer. And so if that's what you want to happen, we can usually provide that. That's a good answer to the question, what do you want to happen? Sometimes, though, we'll get other answers. We've had people looking for apologies. We've had people who feel they've been so wronged by their business partner or competitor that they want the other side to apologize. That's not what courts do. We can't offer that. Oftentimes, you'll hear people who really just want to prove a point or the principle of the thing. Also, not a good reason to enter into commercial litigation. You're setting yourself up for failure. An in-between reason, in between the good and the bad, is the group of people who come in and say, look, I've been negotiating with this party, this counterparty, this adversary for 6 months to try to resolve this problem. They don't want to deal with me. I can't get them to be reasonable. I can't get them to come to the table. I'd like to, but they're not going to do anything until I push them. And the way we're going to push them is we need to push them through litigation. Sometimes that can be a good goal. Other times that can be very dangerous. It can be a good goal if you are willing to litigate all the way through, if you're willing to fight the fight. If they don't come to the table, if you can't make a deal, you still need to be willing to go the mile and pursue the litigation to its end. You run a big risk if you think that you're going to file the lawsuit and then they're immediately going to settle, or you're going to file the lawsuit, they're immediately going to come to the table and be reasonable. Sometimes that happens. Most of the time it doesn't. And so anybody who's coming in saying, I just want to file a complaint, and as soon as they see that we've initiated the litigation, they're going to come to the table and it's all going to work out. Very, very risky approach. Also, when you're considering what you want to happen in the litigation, it's also important that you consider what happens if you do nothing. Oftentimes, our clients come in and they have a viable claim, they've been wronged, but they haven't fully considered what would happen if they do nothing. And so it's really important that that potential plaintiff play out, well, what happens if I lose nothing? What happens if I do nothing? Okay, I've lost X amount of dollars, but can I recover it in some other way? Or is there some other workaround outside of litigation? How bad is this damage? Will this blow over in 6 months and nobody will remember it? Does the litigation help or hurt? There's oftentimes this desire to do something. Consider what happens if you do nothing. Another thing we want our potential plaintiffs to consider before getting involved in a piece of commercial litigation is the disruption that litigation can cause to the daily business operations. Most of the litigation we handle involves and requires the participation of high-level executives. It's the president, the CEO, the CFO, the owners, the shareholders. It's not a lower level person in purchasing working on some kind of collection issue. They tend to take a lot of time of people who are already very busy. Another thing we want our potential plaintiffs to consider are the effects and the impact that a piece of commercial litigation will have outside of the litigation itself, outside of the courtroom. What does that mean? Will the litigation create unwanted publicity in the media? Will it disadvantage you in the court of public opinion? That's something to consider. Will the existence of the litigation lower the morale of your employees? Are they going to enjoy being brought in for deps? Is it going to be disruptive to the workplace? Are there additional costs outside the litigation that may not be fully considered? Is the litigation going to interfere with other important stakeholders? Is it going to interfere with a relationship with a customer or a vendor? Those are critical considerations that need to be weighed in the evaluation as to whether to initiate a piece of litigation. Another thing we want our potential plaintiffs to consider is the possibility of disclosure of confidential information in the case. There's a variety of techniques that we have in order to keep documents that are going to be exchanged in discovery confidential. It's possible to get confidentiality orders from the court, confidentiality agreements from the other side. You can limit discovery to some extent. But at the end of the day, if you need to use your company's confidential information in order to prove your claim, then it's going to be very hard to shield that. Even with the best confidentiality agreements, you can't erase what opposing counsel or the opposing client sees in the document production. You can't erase that from their heads. And so there's some litigation that is just going to embrace information that's so sensitive that it makes the litigation particularly unattractive. And so that needs to be considered right from the outset. Another thing we want a potential plaintiff or client considering getting involved in a piece of commercial litigation to appreciate is the possibility of counterclaims. And a counterclaim is simply, I'm plaintiff, I sue a defendant, defendant sues me back. They are the counterclaim plaintiff, I am now the counterclaim defendant. And frankly, the majority of commercial litigation we get involved with involves counterclaims. And the reason is, there's a lot of reasons, but one of the reasons is it's a game that defendants play, for lack of a better term. In the 60s, Eric Berne wrote a book called Games People Play. And one of the games that people play is a game called Now I Got You, You Son of a Bitch. And this is exactly the type of behavior we see when people get sued in commercial claims. So I'm a plaintiff. I'm suing my ex-business partner because he stole $1 million from me. And what do? You get a counterclaim back that he's claiming that I cheated the business by running my cell phone bill through the company. It's a minor thing that enables the defendant to make themselves a victim and an aggressor at the same time. The existence of the counterclaim has a couple of significant practical realities. Setting aside the merits, there's some practical realities that the assertion of the counterclaim creates and that a plaintiff needs to consider. First, it's going to cost more money. It's going to cost money to defend the counterclaim because now not only would we be advancing your claim as a plaintiff, but we also have to defend the claims against you. And there might be a separate set of facts. It may be a broader set of discovery. It may result in additional depositions. It almost always results in additional costs, additional motions practice, the whole nine. And so when you're thinking about kind of litigation budget and cost, you have to think about the possibility of having to defend counterclaims as well. The other practical reality of the counterclaim is that you can no longer just walk away from the litigation. If you're a plaintiff and there's no counterclaims, and halfway through you decide that the cost has eclipsed the benefit, or defendant's going to declare bankruptcy anyway, or you decide to abandon the litigation and you want to throw in the towel, settle it for nothing, whatever it is, you can do that. If you have counterclaims, you can't do that anymore. You are now effectively a defendant in a lawsuit that you don't have a choice but to defend. And so once counterclaims are involved, you can no longer just sort of wash your hands of the case and walk away if something sort of goes awry. So the last thing we want our potential plaintiffs to consider before getting involved in a piece of commercial litigation is cost. And I actually break that down into three separate concepts. One, how much does it cost to advance the claim? What are your attorney's fees? What are your expert fees associated with advancing the claim? Obviously, we cost money, and you may also need third-party experts. Accountants, forensic accountants, business valuation people, industry-specific experts. If it's a breach of contract of some sort, was a product delivered within spec, you may need subject matter experts, chemists, engineers, whoever. All those people cost money. How much is it going to cost to see this thing through to the end? That's the first question. Second question is, how much can you recover? And it's not always known at the outset what your best day is or exactly what your damages are. Oftentimes, you will get a better sense of what your damages are as you proceed through discovery. So oftentimes at the beginning of a litigation, you're sort of using a best guess as to how much you think a reasonable recovery might be. And then finally, if you're able to get a sizable judgment, and if that judgment is much larger than the cost to pursue the judgment, are you going to be able to collect the judgment? Most of our cases have no insurance policy involved. That means somebody has to open up their wallet, a person or a company or both. If that person or company declares bankruptcy, you may have a difficult time collecting that wonderful judgment that you obtained and worked for years and paid for to get. You may have quite a bit of trouble collecting even pennies on the dollar. So all of those things need to be considered at the outset of the litigation.